Okay, today we're going to be talking about limited partnership and limited liability partnerships, and this will lead us into liability for professionals, accountants. So, but we'll probably have to finish that up on Monday because I don't think we'll get through both of those topics, all three of those topics actually, in one lecture. So today, let's start with the limited partnerships. Limited partnerships have been around a long time. LLCs, which we already talked about, and LLPs, limited liability partnerships, and limited liability companies, these are rather new developments. But limited partnership have been long, many more years. Not quite as long as partnership or corporation law, but you know, they've been around a long time. But what it is limited partnerships are basically partnerships in which some of the members do not have personal liability, and they're just simply investors, and yet they receive profits from the business, and it passes through onto their income statement, so there's no double taxation, and it's been around for a long. Every limited partnership traditionally has one general partner, and originally that had to be a natural person, not an artificial person like a corporation. But that has been changed, and I think most states now allow for a an artificial person, a corporation, to be the general partner. So there are changes in there. So that limited partnership means that the general partner is going to maybe assume all the liability for whatever happens at the firm, any negligence or any wrongdoing, any contract, any debt that's incurred, civil penalties, all are laid at his doorstep. Okay, and of course now if he's a corporation, then he has at least the protection of the corporation's limited liability. So, and I think that was originally why they wouldn't allow the partnerships to have it, because they thought, well, it's too much like a corporation, but that's all changed now anyway. Anyway, every limited partnership must have at least one general partner, even today. That's generally true. General partners have an ownership interest and manage the business and are personally liable. The limited partners acquire an ownership interest by purchase, so they're much like stockholders in a corporation, and are not personally liable so long as they don't get involved in managing the business. So they can lose that limited liability status if they start managing things, and sometimes they do that with the general partners knowing they're doing that, but not really interfering, just sort of letting them do it, and but they're not supposed to be doing that. So that could cause them to lose their limited liability status. Anyway, a general partner may be a natural person, a partnership, a limited partnership, a trust, an estate, or a corporation nowadays. So like I said, originally it had to be a natural person. Now all these other kinds of organizations can actually be involved, including a limited partnership. A limited partner may work for the partnership as an employee or as a general partner. In general, a limited partner is not personally liable, but there are exceptions. Okay, so a limited partnership is just a new form that greatly enabled businesses to raise money from people who didn't want to necessarily be liable and didn't necessarily want to own, did not necessarily want to own corporation shares with all that entails. So anyway, limited partner is only liable to the extent of his or her capital contribution, much like a shareholder. The limited partner, as an owner, could lose his entire investment in that limited partnership, in that business. So the money he puts up, he's risking all of that. If he invests $10,000, he could lose $10,000. If he invests $20,000, he could lose $20,000. But that's all. So he's not going to be losing his house. He's not going to be going into bankruptcy for that usually. So the limited partner may be personally liable if the limited partnership is defectively formed. So these are creatures of statute, There's state statutes that create the right to create these limited partnerships, and you have to strictly conform and comply with those statutes. So they require you to file certificates and operational agreements sometimes. Sometimes they're not required to file an operational agreement. You're not necessarily required to have one in some states. So it varies from state to state what's required. So we'll go over typical requirements in a bit. The limited partner may be personally liable if the limited partnership is defectively formed, the limited partner participates in management. So like I said before, anytime that he gets involved in making managerial decisions or ordering people or making decisions that relate to the business in a very direct way, yeah, the limited partners can have meetings with the management, but the management keeps control of the corporation. So just like in a corporation where you separate ownership from control, with limited partnership you have a separation of the limited partners from control, because the shareholders are also limited, and maybe even more so because the limited partners don't vote on directors. So the limited partner makes a personal guarantee of the funds that he commits to. So sometimes he has a subscription, just like people who promise to buy shares. And the limited partner makes a personal guarantee of payment that will make him personally liable for that debt. So if he's, let's say he is not in management, but he actually works for the limited partnership, you can do that and not become liable as long as you're not making managerial decision. But then he's told that the bank is going to call a loan, and he goes down to the bank and said, "Don't call a loan. I won't have a job if you do that." And the bank says, "Well, you know, we need somebody to sign. Maybe you get one of the officers of the limited partnership to come down here and sign." He tries, but he can't find anybody. So he decides to go down and sign himself. He signs a guarantee with the bank and makes himself liable then for that debt that's owed to the bank. So that's the way he becomes liable. So he's not necessarily liable for other debts, but certainly for anything he guarantees he's going to be liable if he signs as a surety. Liability of a general partner in a limited partnership. Theoretically, they are personally liable, but often the person who wants to avoid liability may incorporate themselves and the name of the corporation, or maybe it's an LLC, and name the corporation as a general partner. This ruse may fail if the corporate veil is pierced. So we talked about piercing the corporate veil last time, and I think we also talked about it before that when we talked about corporations. So many lawyers, when they talk about an LLC, will just incorrectly call an LLC a corporation. It's a limited liability company. It's not a corporation. It has no shares to sell. It's a distinctly different kind of thing. But it is oftentimes in many of its aspects like a corporation. So they'll talk about it in general, and people will talk about it that way. Okay, so let me give you an example of piercing the corporate veil. A failure to comply with state regulatory laws. So that's even true whether it's setting up the business. You have to comply with the provisions. You have to have a certificate of a limited partnership certificate, and you have to have names of people investing and who the general partners are and who to call in case the corporation is being sued, and that all has to be filed. And whatever else the state may require you to file. And there may be annual statements or even quarterly statements that you have to file. Whatever the state wants to require of these are statutory organizations. They're created by statute of the states, and different states might have different kinds of requirements, but like I said, we'll look at some of those in a minute. In setting up or in the conduct of running a business, in those cases, you know, what's going on there, if there's some wrongdoing or they didn't strictly comply with the statute in some way, if it's seen as being important, the Attorney General for the state may bring a case and sue them. So we're going to be talking later about a case involving an Ohio limited partnership with an LLP, and in that case we're going to find that a party who thought he had limited liability under the organization that he set up, wound up being liable personally for the debt of the corporation because he acted in a way that was inconsistent, and he was named as the general partner. And so general partners can be held liable. He tried to claim he was only a limited partner, that he was, indeed, he was a limited partner in the general partnership and had a corporation set up, and he was trying to use that ruse to get out of it, but he was actually general partners in both the LLC and the limited partnership. That didn't work. So Governor DeWine brought the case as Attorney General of Ohio at the time and made him pay. So he wound up paying the civil penalties for the environmental regulations that he violated. Okay. For example, failure to comply with the state's regulatory law in setting up or in the conduct of running the business. So you're not having the business run according to the state's or even federal regulatory laws. The state can say, hey, you're not, complying with statutes here. Certificate of limited partnership. Okay, so what's in the certificate of limited partnership? Pretty much every one of them is going to have same things. A name of the limited partnership, so people can identify it as being a limited partnership. So that's going to be listed. There's going to be a file. People can go and look it up and get these documents that you're going to file with the state. Usually it's filed with the state's Attorney General. General character of the business. So are you a airline? Are you flying people, passengers? Are you flying freight? Are you a freight airline? Are you a passenger airline? Are you both? Are you just a transporter of goods and you got trucking companies too? Are you a conglomerate? So you need to say what it is, what business you're doing. General character of the business. Some businesses, conglomerate has a lot of things that it's doing, but a lot of businesses are very more narrowly. So people who might want to invest in a limited partnership would need to know what kind of business they're getting involved in, because people oftentimes have, want to invest in certain kind of things. Like right now, I imagine it's maybe hard for airlines to raise money. They're not doing so well with the COVID-19. That may pick up once things get under control better. If we come out with a vaccine, maybe people will get more think that, well, these businesses now can maybe make some profits that they're not making now because of having to fly with empty seats and all the rest, and not having as many flights, but still having the planes and having to service them. So they still have to have their crew, ground crew, working on them. And although they might save some money by shortening the hours that the employees work, so that's kind of tough. Address of the principal place of business. So you have to have a principal place of business, and this would be usually your home state, So, and the reason you want to, say if you were in Indiana, you would want to locate and have your limited partnership in Indiana, and maybe you might want to have an LLC in some state like Nevada or Wyoming, which are very good states for shielding your assets from liability. However, there are problems with that. So you need to have an attorney set that up for you. So you might want to have both an LLC and a limited partnership, an LP. So you need the address of your principal place of business of the limited partnership, and when you file your LLC, you'll have to tell them that place of business. So these statutes have a lot of similarities. Name and addresses for service of process. So if you're going to be sued, who do I send the papers to? It's going to probably be your attorney. And so you'll have an attorney usually in the state of Indiana if you're organizing in Indiana, who's advised you on the Indiana law. And if you are indeed also establishing an LLC in Wyoming or Nevada, which are very friendly towards LLPs and LLCs, if you're doing that, you're going to need to also have an attorney there to advise you, because these things have to be set up right. And oftentimes firms will have people in multiple states Although there are still some sole proprietors and small partnerships that operate solely within the state. But I think a lot of the major law firms have either branches in other states, or they have firms that they affiliate with. So it's not a problem. Name and address of all the partners. So you got to name all the limited partners. You got to name all the general partners. The general partners have the risk of personal liability, so that's obvious why you need that for them. Why do you need it for the limited partners? Well, just because you need it. It's because the state says you need it. I don't know what the reason for that is, but that's what they do require. And in some ways, it's good, because sometimes a corporation isn't rightly formed, and then if they don't follow the statute and don't comply with what the statute requires, then those limited partners don't have limited liability. They're personally liable. It becomes just an ordinary partnership, and they become general partners, and they lose their limited liability status. So that's something you would want to happen. So you need to look carefully and see whether or not, if you're joining a limited partnership, whether or not it's complying with that state's law. And it's not good. Let's say you want to buy into a limited partnership that's operating in South Dakota, because you heard it was a great limited partnership and had great opportunities to make money, and you wanted to get into it. You probably need to talk to a South Dakota attorney about that. But maybe your attorney locally has somebody he's affiliated with, and he can set you up with them to get that kind of advice, or he'll get the advice and relay it to you. And so that's just the way you need to do it. So name and addresses of all the partners. Latest date for dissolution of the partnership. So these limited partnerships were typically limited affairs. They were not designed, originally at least, to be in perpetuity, but I think nowadays they could be operating in perpetuity, and it's simply a matter of renewing it. If you have to, under the state statute, have a date of dissolution of the partnership, you set that date, and then you set up in there a provision that this date can be extended out, and you don't put any limits on that. So extend it out beyond that. And you just kind of leave it at that. So in other words, you could just always extend it. And then you would, at that time, you might rewrite the certificate of limited partnership, and it'd be, in some sense, a new limited partnership, but then again, maybe not. So you have this thing with, you see this with law firms and accounting firms, where, there's a firm in Cincinnati called Taft, Titinius, and Hollister, and you can look in vain for an attorney named Taft on there. There have been Tafts on there over the years, but I don't think there's currently a Taft on there. There's somebody who's probably there's some people who are descended from a person named Taft, but they may have different names. Like one of the Supreme Court justices on the court at one time was a grandson of William Howard Taft, the president Taft, and but he didn't have the Taft name. Anyway, he's famous, actually. I just can't think of his name. His most famous statement is, "I know pornography when I see it." And so if you look up that phrase, you'll find his name. And there's also two Harlans on the court, and they were related. There's two Marshalls, but they're not at all related. Okay. Latest date for dissolution of partnership, then description and amount of capital contributions, so we know what kind of capital they have. The corporation, one of the things about, one of the traditional ways of disregarding the corporate entity, or rather piercing the corporate veil. My lawyer, my teacher in law school who taught me corporation would talk about piercing the corporation as being disregarding the corporate entity, that's what he would say, instead of piercing the corporate veil. He said that was far too sexy. I don't know. I didn't get it, but it's okay. That's the way he wanted to say it. But it did make a point. What it actually is, it's rather more descriptive of what we're talking about here, disregarding the corporate entity. Other matters included by the general partner. So other things can be put in there, and maybe some things you might want to put in there for probably some good reason. Rights of limited partners, with exception to participation in management, which they have no right to do, right? If they do that, then they're no longer limited partners. They have the same rights as general partners in any partnership, including access to the partnership books and to information in regard to the business operations going on and to what things are happening in the firms. They have a right to come in there, demand to know. I heard this rumor. Is this true? You know, you got to deal with them. You got to tell them. They're the owners, for heaven's sake. You know, they may be owning a very small part of the business, but to them, that's a very big investment. Maybe that $10,000 may not seem much to you, but to them, it's maybe a lot of money. Return of their contributions upon dissolution, right? So of course, you would have that. You have a right to actually any share in the what's left over after the creditors get paid, right? So they sell off all the assets, they wind up the business, and then they give you what's left over of the assets. And obviously also, if you're a creditor of them, you would get your loans paid back before you get those shares, you know, because that could come off the top there. Anyway, right to assign their interest to others. So they cannot assign a right for a person to become a partner, even a limited partner. You know, so if they want their wife to become the partner, they can't assign that right, but they can assign the right for her to receive the contributions, the dividends, the distributions made by the firm. And if when it winds up, that person you designate would as having the interest, maybe after you've died, would be entitled to a share in the asset distribution and to whatever left over, to any profits and the right to your contribution back. Hopefully they still got your money. You know, it is a business, and you could lose at that final. You may not get your contributions back. It may, oftentimes, if it's going out of business, that's the case. Certainly, there were a lot of people who lost huge amounts of money at Enron. So it was selling at over $80 a share, and it went down to 14, 16 cents in just a few short days. Right to assign their interest to others. Right to file suit on behalf of the partnership. So if the general partners, or the general partner, if the general partner or partners, if they don't file a suit and you think a suit needs to be filed, you can bring it. But first you need to check to see whether the partnership is acting. If they're not acting, you can bring a suit if you think. And it may be that, let's say there's two partners and one of them has been engaging in embezzlement, has embezzled money from the limited partnership. That's your money. And so, you know, and you talk to both of them, but neither one of them is doing anything. You decide to bring it on your own. So I think we could talk about that too. You can do that. You go out and hire your own attorney, and then the money you recover belongs to the partnership, but you as an owner have an interest in that money. And anyway, return of their contributions upon dissolution. Now, we said the right to assign, no, we already did that. You know. Okay, causes of dissolution, except when all partners agree to continue. These are things that will cause the partnership to have to stop. Bankruptcy of the firm or the general partner. Okay, so he's the guy who's going to be basically going in and borrowing money from the banks, and the banks are going to want somebody to sign. So can you continue to do business if you can't get loans from the bank because your general partner can't sign because he has no credit? You know, he's filed bankruptcy, and they're not supposed to hold bankruptcy against people, but let's just say that he's in the process of filing bankruptcy, so at this point he has no credit or very bad credit rating. A retirement of the general partner, okay? You need to have him replaced. So, you know, absolutely, you could agree as partners to get some new general partner, but you have to find that person, and you have to find somebody willing to be the general partner, and he has to step in and take over. The death or disability or mental incompetence of the general partner, that dissolves the partnership also. Now, death and disability and mental incompetence of a limited partner causes dissolution of that partner. So he leaves as a partner, and he may have some interest that survives him, but he's no longer a partner. So. Okay, now this is a case I was talking about earlier. It's called DeWine versus Valley View Enterprises Incorporation. So that was a limited partnership, and Ferrara, this is the fellow who's the general partner. He was a general partner in Valley View Enterprises Incorporated. So that's an LLC, and so he could set that up. And I don't know whether he set that up in Ohio or whether he set it up in, say, a friendly state like Nevada or an unfriendly state like California. If you're going to do an LLC, you probably don't want to use California because it's the worst at shielding your assets. But I guess if you're in California, you may feel like you need to do that for other reasons. But LLCs, there's some cases in California. I think there was actually a piercing of a corporate veil in a case in California. Anyway, so we have it here with Ohio. Okay, so Valley View Properties Limited. Now that's a limited partnership. Ferrara was the sole GP of Valley View Properties Limited. And Valley View Property Limited put in a swimming pool for Valley View Enterprises Incorporated. So he's a general partner in this LLC, okay, and he's also the general partner in this limited partnership, and he is the one who's actually managing that limited partnership, and he's directing the people who are constructing the swimming pool, and he doesn't file the necessary forms to show that they're complying with environmental regulations, and they didn't comply with environmental regulations. And so the Ohio Environmental Protection Agency, because they have their own protection agency, as some states do, and actually I have a son-in-law I have a stepson who actually works for them, and he would maybe be involved in something like this, but I don't know that he was involved in this one. Anyway, they weren't following the environmental rules, and so the state of Ohio was, assessing civil fines against this Valley View Properties Limited. Okay, and of course the limited partners are not going to be liable, so whatever money they're entitled to, they get to keep. But he's the general partner, and he had set up the Valley View Enterprise Incorporated. Like I said, I don't know where he did it, but he set it up to avoid liability. Okay, and it didn't work, because they pierced the corporate veil. And this is, like I said, this is an LLC, but we oftentimes talk about these LLCs as corporations, because many of the laws of corporation do apply to them, but also the laws of partnership apply to this Valley View Properties Limited. And so he is liable because he was managing the work. And in a sense, he was even an employee then, because he was doing a work. He was managing, he was supervising the installation of the pool, and he didn't do a good job. So there he could be liable just based on that, but they found him liable because he was the general partner of Valley View Properties, not because he was a general partner of Valley View Enterprise Incorporated. In the lower court, they must have gotten confused, and they didn't hold him liable. But Attorney General DeWine, who's now did such a good job as Attorney General that we elected him governor, he brought this case against them, against Ferrara, and they held that the Valley View Properties Limited was liable for it. However, you can only take from the general partner there, and so it has to pay fines, and he's also responsible for fines, and so he's going to pay the entire bill, I think. And I think he's probably just set it up that way. And I think a lot of people in the real estate business and businesses that work with real estate. So a construction company like this does a lot of work for homeowners who are installing that. So, and it does a lot of work for people who are building homes and selling new homes to do that. And and they're used to setting up these kinds of instruments in order to avoid liability. So they're owning properties and have an interest in different properties usually, and so they oftentimes have numerous LLCs and limited partnerships and LLPs in some cases if they're actually a professional. Although real estate agents are not necessarily professionals, I don't think. Although they do have a code of ethics, I don't know if they actually enforce those codes, like lawyers and doctors and dentists enforce their codes. So you can lose your license, and people have lost their license in those professions. So they're true professions. So I'm not sure real estate agents qualify as true professionals. I mean, anybody can call themselves a professional, but a true professional would have a code of ethics that's enforced. I'm not sure that's the case with maybe there's some real estate somewhere being sold, maybe some real estate group is actually enforcing its code. I just haven't heard of it. I think it's oftentimes brought up in lawsuits, so in which they're involved. So it's against your code, and so it's not just an understanding. So it's not like Pirates of the Caribbean, where that's just an understanding, right? So property limit was found civilly liable. The trial court found him not liable as a corporate officer because he was a corporate officer according to them. And Ohio's appellate court reversed and held Ferrara liable for the fines. So didn't escape. Defective formation of limited partnership occurs if statutory requirements are not met. For example, failing to file a certificate of limited partnership would be, you got to file that certificate. You got to strictly conform to the statute. You got to have everything in it that's supposed to be there, and everything should be correctly there. You put down the wrong information, you haven't filed your statute correctly, and therefore the limited partner is not. So if you were buying into one of these things, you might want to look at their certificate of limited partnership, especially if they're just newly formed, and make sure that they've done everything correctly, because otherwise you need to act quickly to avoid becoming liable as a general partner. That is, you need to withdraw from the partnership and demand your money back, maybe, or disavow the limited partnership. There's two ways you can do it. Anyway, the limited partners may still be liable to parties who believe they were general partners at the time of the transaction. So if you're actually somehow implicated as being seen as somebody who was a partner, so you want to make sure that you're not a poster boy for the limited partnership, that they're not using you as one of their partners in order to sell, and giving your credibility to other buyers who think, oh, it's okay because I know George is a good guy, and if he's a partner in it, he must be good. So that's a problem. Limited partners must act quickly to avoid personal liability by either causing firm to meet statutory requirements, which is one thing you can do, or by withdrawing from any equity participation. You're still entitled to get your money back, but you're not entitled to any growth in money if you want to avoid being held liable. Limited liability partnership. And certain people have been held liable like that, where it was, I remember there was a South Dakota case, some people in the Midwest, I guess South Dakota is part of the Midwest, right? The greater Midwest, but some people on this side of the Mississippi River bought into the South Dakota, and they didn't know anything about that South Dakota thing. It turned out that they had not properly filed their certificates and their information that was misleading. Anyway, so that's meant that they lost some money, actually, I think, in that case. Limited liability partnership, a hybrid form of business organization. So now we're talking about limited liability partnership, which originally was designed for professionals. So the idea was originally to allow professionals to escape from the malpractice of other people within their firms. So partnerships like law firms and accounting firms had grown to be quite large. There was a time in which partnerships would just be a handful of people, but that's long gone. And nowadays, a lot of these accounting and law partnerships have numerous people, hundreds of people, thousands of people sometimes, and they're spread out across the United States and even internationally, and nobody knows everybody. So, you don't know that some guy over in South Dakota is screwing up and going to wind up costing the firm a lot of money, and you'll be maybe liable for that. And so you would want to avoid that. And so, but then again, having large professional partnerships like this are oftentimes advantageous for the consumer, because like I said, you might sometimes need to have them have some affiliation with that, and nothing better than to say, oh yeah, well, we have members of the firm who are there and they're experts on this, and they're part of our firm, and so we can guarantee them, right? So that's it's like McDonald's, right? There's a certain advantage to going into McDonald's because you know what we're going to get wherever it is, whatever part of the country you go. When you go into McDonald's, you know that the hamburger you're getting there is the same as the hamburger you're getting in Indiana. Anyways, a hybrid form of business organization which was originally designed for professionals. They have, however, been more broadly used by all kinds of businesses, individuals, families, and even farmers as a way of shielding their assets. So other people said, yeah, we want to shield our assets too for other reasons. But, so this became something that they did. Nobody was quicker to do that than the real estate people. So, I don't know whether they claim to be professionals. Like I said, I don't consider them professional. I'm sorry to anybody who's a real estate person out there. I once thought about getting into real estate, but I didn't. As a student, I studied for it. The only benefit I got from it was I had the highest grade in Property 1 in law school, which I learned all that Property 1 when I was studying for the real estate exam, plus some other stuff it didn't help me in law school at all. But anyway, LLPs, professional malpractice. So LLPs allow professionals to avoid liability for other professional members of their LLP, for other professional members who have committed malpractice. They remain liable for their own malpractice. Okay, so if you commit malpractice, you're going to be liable for it. Typically, you buy malpractice insurance. Okay, you're required under the state bar to have malpractice insurance if you're practicing law, and if you don't, that's grounds for kicking you out of the profession. So you definitely want to have it anyway. Including, now you can also be held responsible for, now the one way you could be held responsible for malpractice committed by either a member in your firm or by even an employee of your firm. You could be held liable for malpractice if you were supervising that other professional member. So I know law firms usually have associates. Accounting firms, I believe, have the same thing, have associates, and dental firms will take in people and train them. And so these are like training people, but they're oftentimes professionals, and they're they also can commit malpractice. And if you are taking these people in, you need to supervise them. That means you need to assign somebody to supervise them. So every associate has somebody who looks over his work. I remember I interviewed for a job, and literally the guy told me that I was going to be sitting at a desk, and my desk was going to be up against a wall. I'd be looking at a wall. I didn't like that idea. And he would be sitting behind me. And I had been highly recommended to him, and I believe I would have gotten the job with him if I wanted it, but I said I didn't want it. I didn't like that setup. I didn't like somebody looking literally over my shoulder. I mean, I don't necessarily mind being supervised, but that's a little much. Anyway, but maybe he feels that's the best way to do it. And he certainly has a right to run his firm and his supervision anyway, because he's going to be liable for whatever I did. So I can understand his point of view, but it's just not what I wanted. Okay, so professional malpractice, professional members and supervising firm employees can become liable for those other people. Okay. Liability for contracts and torts. The Uniform Partnership Act exempts limited liability partners from ordinary debts arising from contracts, unpaid local taxes, civil penalties, ordinary negligence, strict liability, and intentional torts. So you can see why it's useful for other businesses, service businesses, and other kinds of businesses use this. Under traditional partnership, farms use this. Under traditional partnership, these debts were shared jointly and severally by the partners. Under statutes, even a supervising professional is held at fault. They are given proportionate liability. So some of them are given proportionate liability, and some of them are actually held to be jointly and severally liable. So it kind of depends upon the state and maybe even the agreement that's agreed to. Anyway, limited liability partnership liability insurance. Many states require a minimum amount of malpractice insurance to be carried by professional firms for negligent and wrongful acts and misconduct of the partners, agents, or employees. So malpractice is basically a form of negligence, isn't it? Limited liability partnership. Many states allow for LLPs. That does not have to be. There does not have to be a general partner in an LLP. All partners can be limited and are not liable beyond their capital contributions. Usually LLPs are restricted to professional organizations. That's an old rule. That's no longer true. Must be formed and operated in compliance with the state statutes, although there are probably some separate statutes now for professionals, I guess. Maybe specific professionals. Articles of LLP must be filed and become publicly available. To do business in another state, the LLP must register as a foreign limited liability partnership. Common law partnership laws and statutes and precedents are applied to them typically. Liability outside the home state of formation. Limited liability partnerships are required to file a statement of foreign qualification in it. An Indiana law firm operating in Kentucky, Illinois, Michigan, Ohio, or Wisconsin, which they might well do if they're on the border, would need to file such a statement in each state if it were to open offices there. And many of them will have that. Family limited liability partnership. All partners are related to each other except a fiduciary such as a bank or other trustee may handle important assets in the interest of the member, but a bank really can't be because it has to be a natural person. So I guess if it's a sole proprietor, are there banks sole proprietorships? I don't know. Anyway, of a member beneficiary. So if there's a member beneficiary who needs an agent, you might have a fiduciary and he will be treated differently. So he won't be related to maybe the child that he's a guardian for. So this might be a guardian. All partners must be natural persons. Okay, so in Iowa, Family LLP exempted these business organizations from real estate transfer state taxes. So you can see why they would have that. That facilitates the handing down of the business, the farm, to others. I have a lot of farms in Iowa. Okay, and they have an FLLP. So that's it for today, and thank you very much.